Thank you for joining us. My name's Kimberly Inksader. I'm director of Just Governance Group. I wanted to just flag that we are doing a video recording of this so people can see it later. So if you don't want to be visible or your name to be visible, please change your name in your Zoom profile. Of course, while we're listening to the speakers, we'll keep our microphones off. If you want to hear the Burmese translation, there is that option. My colleague Tin is helping with that. Tin is a research fellow at Chiang Mai University, and he's been working with me with regard to work in Myanmar for Global Affairs Canada. Before starting, I wanted to give our land acknowledgement. The Just Governance Group offices are located in Ottawa, and we are on the unceded, unsurrendered territory of the Anishinaabe or Algonquin Nation. They are the original custodians of this land, now known as Ottawa, and we honor their presence and their culture and their ongoing contributions. We also honor all Indigenous peoples in the lands where you are located and recognize that Indigenous peoples have a right to self-government. I wanted to explain first, before we get started, why we selected this topic. We have been conducting research on local governance, public service delivery, and administration of justice by non-state actors. And we were intrigued with recent academic work around rebel governance, and particularly the administration of justice by non-state groups, including armed actors. And today, we're privileged to have three guest speakers to discuss international human rights and humanitarian law related to justice administered by non-state groups. And we're going to then focus on specific experiences related to ethnic states and other regions in Burma or Myanmar. Each speaker will have approximately 12 minutes to present their key ideas, and we will then have an open discussion. You can pose questions in the chat function if you wish, but you can also ask a question verbally, on the video during the question period or discussion period. Are there any questions before we start? Our first speaker is Professor René Provost. He teaches at McGill University in Montreal, Quebec, and he conducts research in public international law, international human rights law, humanitarian law, and Indigenous legal traditions and legal theory. In 2021, Oxford University Press published his book entitled Rebel Courts, The Administration of Justice by Armed Insurgents. In that book, he examined rebel courts in Colombia, Sri Lanka, different Kurdish regions, Afghanistan, and other contexts. So I'll ask Professor Provost to begin.
Thank you, Kimberly, and thank you everyone for joining us to talk about this important topic and also this important region that we speak about less these days than probably we should. It's been overshadowed by other conflicts in world media, but of course that does not mean that the reality on the ground has gotten any better. So happy to join in. So what I aim to do in the next few minutes is to basically map out some of the legal issues arising from the decision by non-state actors in conflict zones to establish their own systems to administer justice. As Kimberly noted, I published a book a few years ago on this. I spent 6 years researching and writing this book. It's an enormously complex issue, and so there are many areas. So I will flag issues more than go in depth into any of them, and we'll be happy later to either connect that to some of the comments made by the other interveners more specifically related to Myanmar or questions related to specific legal dimensions. So the legal administration of justice by all groups is a reality that is largely unrecorded or actively suppressed by government. And as a consequence, it is a practice that has been broadly unexamined or reduced to a power grab by armed actors. And it's important to um, address this issue because it matters tremendously for the everyday life of people under the authority of non-state actors. Security in general and legal security in particular is an essential human need, and armed groups often take on the mantle of providing the administration of justice to address that need. International law does contain tools that allow us to give some answers as to the admissibility or validity of the decision to establish a rebel court and the conditions under which its operation will make it a legitimate activity. So this the international question is primarily international humanitarian law, but also international human rights law, international criminal law, and general principles of public international law. So there are, as I said, many issues. I will quickly flag 6 questions in the next 8 minutes or so, just so that they are present in your mind. And as I said, we can come back to that because I will not go into depth for any of them. There's a first question, which is the compatibility of the administration of justice by non-state armed groups with the basic idea of the rule of law. It's important because very often armed groups are labeled as terrorist organizations by the state. This is a practically universal practice by local governments to designate armed groups as terrorist organization. And quite naturally, it flows that there is a conceptual incompatibility between terrorism on the one hand and the rule of law on the other hand. I think that this is a view that can be quite forcefully challenged because the concept of the rule of law, as presented in this position by many governments, turns on a particular definition of the rule of law that is not necessarily accepted. The rule of law is what's defined as an essentially contested concept. So its content is systematically contested along a number of parameters. There are thin or thick versions of the rule of law in the enormous literature devoted to this issue. I'll note here specifically the association of the rule of law with the state and the claim that the idea of state sovereignty implies a claim of monopoly over the creation of legal standard and the administration of justice by the state. This is a claim that is actually very difficult to sustain in light of the fact that firstly, the implication or involvement of states in the creation of law and administration of justice is a relatively recent phenomenon. And secondly, that it is always an incomplete phenomenon. There is non-state law and non-state justice in every country in the world, and in many countries it is the dominant or primary source of law and justice. So it is possible to challenge the necessary association of the rule of law with the state without necessarily falling into a system of vigilante justice where absolutely anything and everyone can claim to administer justice. So it is possible to identify delimiting criteria that enable us to identify what connects to the rule of law and what is simply an abuse of power. A second issue or second question is turning more specifically to public international law and humanitarian law and human rights law, is to ask whether there is, on the one hand, a right or a duty on the part of armed groups to create their own court system, or to the opposite, a prohibition in international law for groups to do so. There is a particular provision that speaks to this issue, Common Article 3 of the 1949 Geneva Convention, a set of conventions that have been ratified by all countries, including Burma, which says that it's a crime to execute a judgment issued by a court that was not regularly constituted. And that is the standard that we have to work with. And it begs the question of what is a regularly constituted court, and whether a court may be regularly constituted by an actor other than the state, including by a non-state actor. So there's a significant ambiguity in Common Article 3, but the general principle of the equality of belligerent, founding principle under international humanitarian law, suggests that if non-state armed groups are not specifically or explicitly excluded from the possibility of creating or constituting courts, then they have to be considered as having the right to do so. Brings us specifically to a third issue. What is a regularly constituted court? How do you regularly constitute a court under international humanitarian law? This connects to a human rights standard which speaks to the right to be tried by a, quote, tribunal established by law, unquote. So this directs us to a number of ideas. Firstly, what is a court? In the practice of non-state actors, there are many institutions, some very formal, some very informal, and not necessarily all of them can be constituted as courts. There are popular tribunals, or the gacaca in the post-genocidal Rwanda that come as example. How does an armed group regularly constitute a court? This speaks to a court that is not an ad hoc institution created for just one case or one person, but rather an institution that is established to administer justice in a more regular fashion. And finally, regular constitution and the idea of court speaks to a certain minimum idea of independence and impartiality as elements that differentiate courts from other public decision-making bodies. A fourth issue is turns on the jurisdiction of rebel courts. There are a number of issues there. Firstly, the territorial jurisdiction. If such courts can or must be lawfully recognized, what is their territorial reach? we see in the practice of armed groups that not really rebel laws or norms have an extraterritorial reach, just like states' laws have extraterritorial reach. And so there's specific examples where armed groups explicitly stated that their laws applied beyond the territory under their control. And likewise, armed groups have shown in the past that they are able to enforce their standards in an extraterritorial manner, even outside of areas under their control. Subject matter jurisdiction, this covers not only criminal matters, but also civil matters. And I will just say that the practice of state group is that sometimes they create their own laws, but sometimes they apply state law, sometimes they apply international law, other times they apply non-state standards like religious law, Sharia law for certain armed groups. And finally, personal jurisdiction, over whom does rebel justice apply? Its own fighters, individuals, civilians under their control, but also possibly over government soldiers that are captured by armed groups. Fifth, due process in rebel courts. So due process is an issue or an idea at the core of justice. So and a sustained objection to the idea of rebel court and rebel justice is that it is impossible for courts of non-state actors to be fair. So this calls for a sort of a deeper dive into what due process means for non-state courts on the one hand, and in conflict zones on the other hand, to variants that influence the content that international law ascribes to due process. And finally, as a last issue, there are issues of recognition. So armed groups may create courts, they issue decisions, and then what? So recognitions can arise at 4 different levels. So international recognitions by international courts, including the international criminal courts and issues of complementarity, or human rights tribunals with the standard of exhaustion of local remedies. It can arise transnationally in the recognitions by other states of decisions of rebel courts. This has already occurred in various jurisdictions. National jurisdictions, national recognition, sorry, by the state against which the armed group is fighting. So here is the government of Myanmar free to entirely disregard decisions of rebel courts? And finally, transversal decisions where one armed group recognized the decisions of another armed group. And we've seen that in a number of places, including in Burma, where reportedly the Karen National Union and the Mon National Liberation Army have a mutual recognition of decisions of the courts of the other. So let me stop here and leave the floor.
Thank you very much. That, I think, set the stage for some of the main issues to examine this morning. Or I'm going to now introduce Zarli A. I hope I'm pronouncing that right. Da Zarli is an advocate and human rights defender from Myanmar. She has an educational background in law. She's a senior legal advisor for the International Commission of Jurists and an advocate for human rights in Burma. She is of Chin ethnicity and works with justice actors in ethnic states and also Weimar regions to support their justice reform initiatives. In 2018, she was appointed as Peace Ambassador by the European Commission, and she also represented Myanmar at the One World One Young World Conference in The Hague. In 2023, she was awarded a fellowship at Roehampton University in London, in the United Kingdom. So I'd like to ask Zarlee to start. Will you be using a PowerPoint, Zarlee? Okay, I will make
Yes.
you co-host so you can share.
Okay. Thank you. So can you all hear me clearly? Okay, so thank you. So first of all, I would like to express my sincere thanks to the organizer for inviting me to share on the topic of non-state justice in the context of a Karenni state. Before I begin, and I would like to offer a brief disclaimer. I'm not from Karenni, and I'm from Chin, as Kim already mentioned in the introduction. And my experience working on justice issue in Karenni began only after the coup, but in fact, I have been focusing on this area for just a few months ago. So therefore, please bear with me if I'm not able to cover certain details that you may be deeply familiar with. However, I will try my very best. And I will share today is based on publicly available sources and recent conversations with justice actors in Karenni. So as my availability of the time slot is just only 13 minutes as a lawyer myself, so that is so difficult for me. So that's why I write it down all of my scripts, so so that I do not consume my other fellow panelists, speakers. So please allow me to share my PowerPoint slide. Okay. Oh, where is it? Okay. So before I diving into the Karenni justice landscape, I would like to briefly highlight the broader situation in Myanmar, which most of you may already be aware of. Myanmar are currently under the military coup from since 2021 February 1st. So actually, this is not our very first time. We have been experienced the coup since in 1962 and also 1988 and also 1990, which is, we can name it like a silent coup election because of election nullification. So this slide shows the number of arrests and killing resulting from violence involving both the SAC and resistant actors. From my perspective, the situation of Myanmar after 2021 should not be described simply as a civil war. It is more accurately understood as a people's defensive war. The human loss has affected all sides. However, based on publicly available information, more than half of Myanmar's territory township is now under the control of various resistance organizations. In parallel, the military junta and its affiliated political party are preparing to hold parliamentary elections in two phases, scheduled for 28th December 2025, and the second phase will be on 11 January 2026. In July 2025, the junta enacted the Protection of Multi-Party Democratic General Election Law. Under this law, nearly 200 individuals have been charged and given maximum sentences, often through multiple charges, without due process or access to legal counsel. At present, under my direct supervision, our legal team is representing 3 clients involved in 7 cases under this law, each receiving sentences amounting to 42 to 49 years consecutively. So with that, let me move to the next slides. Currently state of geography, peoples, and cultural context. Although many people commonly refer to the state as Kaya, in the term Karenni is more accurate when we speak about the wider group of 9 ethnic nationalities who belong to this state. Kaya is actually just one of these ethnic groups, whereas Karenni reflects the broader ethnic compositions. Geographically, Karenni State is located in eastern Myanmar, sharing borders with Shan State to the north and the northern Thailand to the east. The state is home to 9 distinct ethnic groups, each with its own unique dialects, cultural values, traditions, and customary practices, many of which have been preserved and passed down through generations. These diverse identities and traditions significantly influence how justice and conflict resolution are understood and practiced in the communities. Let me now turn to the non-state justice structures operating in Karenni. Before the recent military coup, the Karenni National Progressive Party, founded on 2nd May 1957, had already been playing a major role in governance and justice matters. Historically, KNPP, which is Karenni National Progressive Party, emerged in response to the Union government's actions following the loss of Karenni's independent status in 1948. Over time, KNPP developed key governance institutions, including the Karenni Ministry of Justice, which is known as KMOJ in short form. This institution has long contributed expertise and human resources to the broader justice architecture inside Karenni, including KSIJ and KSCC and KSIP, which is KSIJ is Karenni State Interim Judiciary, and KSCC is referred to Karenni State Consultative Council, and KSIP is Interim Parliament. Both KSIJ and Karenni Ministry of Justice continue to deliver justice services to the people, and the Department of Justice of Karenni Interim Executive Council was established through the IEC of the state, which itself derives its mandate from the KSCC. So at first glance, the institutional structure may look complicated, but once we understand the relationships and the way these bodies complement each other. Let me now move to the formal justice structures under the Karenni State Interim Judiciary. In early 2025, the KSIJ released its annual court report. The report highlights the justice system applying 3 main platforms, which is number 1 is formal court, and second is relevant customary practices and alternative dispute resolution mechanism. Under the leadership of KSIJ, the High Court of the state functions as the highest judicial authority. Below it, there are 2 district courts and 8 township courts operating across the state. The report notes that people continue to use the courts, and judges often apply existing laws where appropriate. However, the integration of customary practice and ADR, which is alternative dispute resolution mechanism, is not yet fully documented. There are no clear written guidelines or standard procedures describing how these methods should be applied. At the same time, decades of public distrust in the judiciary under the military regime have created significant challenges. Many people remain hesitant to rely on formal courts due to limited understanding of court process, language barriers, or frequent delays and adjournment, and the overall of the confidence in the state-run legal institution. Because of these factors, communities continue to rely more heavily on customary justice system, which they perceive as more accessible and responsive to their needs. Customary system, however, come with their own complexity. Many customary practices are deeply rooted in patriarchal norms. As a result, women and often children and gender minorities are largely excluded from decision-making spaces. There is also a common saying, let the big case become small and then let the small case disappear. This reflects the emphasis on maintaining social harmony rather than focusing on accountability or proportional punishments. While this approach can be helpful in preserving community cohesion, it can also result in insufficient protection for women, children, and other vulnerable groups. As someone who belongs to the minority ethnic group myself, I fully respect customary tradition as part of our identity and culture. At the same time, I strongly believe that customary practice should not discriminate on the basis of gender, age, language, clan, or any other status. For this reason, we should work toward integrating customary justice with basic human rights principles in economic, social, cultural, and even criminal justice matters. When we look at why people choose customary system, the reasons are clear. So because of these practices are closely tied to religious and cultural belief, and also many communities faces transportation challenges, long travel times, court delays, and high expenses. And formal court sentences often feel disproportionate or disconnected from the reality of the community life. So compensation-based outcomes are preferred based on the report. And people also value timely resolution, accessible procedures, familiar language, and processes that align with their beliefs and deliver satisfactory outcome. In short, customary systems because they are accessible, affordable, culturally relevant, and faster, even though they still require reforms to protect the rights of all community members. According to the 2024 annual court report, there are still significant gaps within customary practice. This assessment carried out by KSIJ, which is Karenni State Interim Judiciary, as well as findings from the Government of Karenni State report released in late 2024 and early 2025, show very similar trends. Nearly 60% of people continue to rely on customary mechanism as their primary mode of dispute resolution. In contrast, the use of the formal courts and other mechanism remains very low, just slightly above 0%. Mediation accounts for about 40% of dispute resolution method used by community, which shows how heavily people depend on informal or semi-formal approaches. These figures reflect the ongoing challenges faced by the court system, particularly the lack of access to fair trial guarantees and the barrier that prevent people from using formal justice channels. As I conclude, I would like to emphasize that the slides I share today represent only a brief snapshot of the justice landscape inside Karenni State. What we see in report and structure is just the outer layer. Behind every case, whether handled by courts, customary system, or interim mechanism, there are real people who are seeking dignity, fairness, and meaningful justice. The key issue is not the number of cases processed, but how many people genuinely feel that justice has been delivered. In responding to the broader question guiding this session, it becomes clear that rebel justice is not automatically incompatible with the rule of law. What matters is whether the system upholds fairness, accountability, and respect for rights. Non-state justice does not become legitimate simply because the state of authoritarian. Rather, it emerges out of necessity when people have no other accessible or trusted avenues. International law does not forbid armed groups from administering justice. Instead, it requires that any such system respect basic humanitarian and fair trial guarantees. Recognition of their decision by external actors is always sensitive but limited. Functional engagement may be necessary to protect civilians. And finally, the international community can support justice reform efforts so long as the support is technical, neutral, and focused on improving protection and human rights rather than conferring political recognition. At the end of the day, justice, whether state or non-state, must be measured by its fairness, accessibility, and its ability to protect the people it is meant to serve. That is the standard we should all aim to strengthen. Thank you very much.
Thank you very much, Zarli. That was interesting to hear. I think challenges around customary practices are similar in a lot of different contexts. I recall working in Bolivia around with their pluralism and trying to how do you promote some women's rights and gender equality and change deep-rooted cultural practices. It's a challenge. So thank you for that. We're going to move on to Gianluca. Gianluca Pantaleo is a law graduate from Italy and also from Indiana University in the United States. He's co-author of a forthcoming article on secrecy and international court criminal judgments, and his recent work has focused on international humanitarian and human rights law, as well as justice mechanisms of non-state actors. He's currently advising several actors within Burma's pro-democracy movement on compliance with humanitarian and human rights standards. He also has an interest in constitutional design and the relationship between law and society across South and Southeast Asia. So I'd like to hand it over to you. Gianluca, are you using a PowerPoint?
Yes, I have a PowerPoint presentation here with me. I think you have to authorize me. Okay. Okay, first of all, I would like to begin with thanking you so much for inviting me to this panel, and thank you so much to the other panelists, Professor Provost and Siyama Zarli. It has been a very, very interesting discussion so far, and I'm very eager to touch some of the points that you have already raised. I'm going to talk today about a very specific case study that I've started to know in depth because of my work here on the Thai-Myanmar border with the KNU. And as Siyama Zarli pointed out, I'm also not a member of the KNU and the Karen community. I am from Italy. And so first of all, I want to acknowledge the privilege of being here to talk about the incredible things that the KNU and the Karen people as a whole are doing in their effort of creating good governance structures, but also in trying to respect international human rights and humanitarian standards. And I would like to start my presentation by pointing out, as Siyama Zarli said, that the conflict has started a long time ago. It started since the independence of the country in 1848. The KNU was founded in 1837. As soon as it was founded, the conflict started. And this is in the world, and the longest armed insurgency in the world. The KNU has exercised territorial control over certain areas in Southeast Myanmar, in a region which is known with the endonym of Kotule, the land inhabited by the Karen people. This is also the reason why you can see it's not only called the KNU's justice system, it's also called the Kotule justice system, as you can see from the pamphlet here. So the KNU has controlled these areas for many decades and has administered them as a proper de facto state. this long time control has allowed the KNU to develop a very complex and intricate governance structure, which includes a justice system with codified laws and procedural guidelines. But as we approach the KNU's justice system, we also have to keep in mind a couple of things. When we consider the justice system of the KNU, we have to approach it, on the one hand, considering that there is a clear commitment by the KNU to respect international human rights and humanitarian law. On the other hand, through this codification, through their laws and institutions. On the other hand, we have the reality on the ground, which is a reality of conflict, volatile security situation, and scarcity of resources. And when these two phenomena interact, we have a more flexible application and interpretation of the law. We have a variety of practices and application of these codes and regulations, which basically many of them are still undocumented. So we'll try to talk a little bit about some of them, but also we have to acknowledge that I might be mistaken on some of those practices because they evolved rapidly and not all members of the KNU know about them too. And so I will, after this brief introduction, I will start my presentation. So the justice system of the KNU is mainly composed of three bodies. We have a Justice Department, whose job is to draft, update, and review legislation, which is then approved by the legislative body of the KNU. We also have a judiciary, which is independent from the political organs of the KNU, and it is composed of a four-tier system of justice committees. And I will explain in a minute how these justice committees are composed. We have four levels, as I said. We have a village or village tract, which is basically a group of villages level, township level, district level, or central level, also known as a Supreme Court. Now, at each of these levels, we can start seeing some of fair trial guarantees, because at each level, there is a right to appeal. And the grounds of appeal are also very, very broad. So potentially, any party can appeal a judgment up to 3 times. So if you have a judgment at the village level, you can appeal it and have it reviewed by a township court, and then again by a district court, and also finally by the Supreme Court. Each court has a specific subject matter competence, and this is governed by a very complex system of referrals. So for instance, very serious crimes will not be judged by the village court, but by the township court, and so on. And so we also have, as part of the justice system, a Karen National Police Force, also known as KNPF, which is under the Department of Interiors, and is responsible basically for law enforcement functions and for undertaking criminal investigations. We also have a body of codified applicable laws, which include a code of criminal procedure, a code of criminal law, a code of civil procedure, a law of evidence, despite this last one is pretty old, so it's still currently under review, and then additional pieces of legislation governing specific areas, such as forestry, mining, fishing, farming, or also black magic laws. Now, the justice system is structured in this way because there are some underlying values and principles in the KNU. The first one is basically that they want an inclusive justice system, and that is reflected in the fact that the justice committees have gender quotas. Basically, a justice committee is what we consider a court, and is composed of a judge, which is elected by the KNU Congress at the respective level, and by 2 to 5 members of the Justice Committee, additional members of the Justice Committee, which are in turn chosen by the elected judge. There is a gender quota depending on the level. I think there is a variation in the actual practice, as I said. I think at least 2 women in a committee of up to 5 people should be included in the Justice Committee. But there is a variation, as I say, that there is a gender quota, and women should be represented. Also, despite there is a judge in the Justice Committee, decisions are made by a majority vote. So within each committee, there is a vote, and the majority decides on the judgment. The work of Justice Committees is supplemented and complemented by the so-called community of legal volunteers. The community of legal volunteers is at the intersection between the judiciary and the public, and basically the community. So they have many functions. To some extent, they work closely with the judiciary and within each courthouse as what we would call law clerks. And so, for instance, they assist judges with daily judicial activities, and they also facilitate and manage the system of referrals that I just mentioned. But at the same time, they do help the members of the community in their access to justice. They basically support them with legal advice, and they provide them, let's say, legal trainings, and give them legal awareness trainings also. So they are very, very, they have different functions. They operate at the intersection of the justice system, and the judiciary in particular, and the community in supporting them in accessing the justice system. Of course, they receive a training from the Justice Department and an organization closely associated with the Justice Department called KLAC, which is Karen Legal Assistance Center. But at the end of the day, they remain volunteers. And so there are certain drawbacks in this because they don't get a formal salary for their activities, and there is no formal legal education. They're not legal professionals. They receive a training, but they don't go to law school. And so there is a rate of dropout at the same time. Now, differently from other EROs, the KNU has a formal system of village justice committees or village courts. And this is very particular because, as Siama Zarli pointed out, like at the village level, mainly there is a mediation process. The KNU has like actual courts at the village level, and they are elected by the village leaders. And one member of this village justice committees must be a woman. And also, like this was this kind of court was established to promote access to justice because most of the cases are handled at a village level. And in this way, many people can have access to the justice system in a very easy way because it's very close to their homes, very close to where the facts have happened. They don't have to travel to the townships. And basically, it remains very accessible because it has inexistent cost. There are no court fees to be paid. And so most of the cases are handled and solved at the village level. And there have been some cases where a defendant, for instance, appealed the decision of village justice committees to the township courts. But to my knowledge, these cases are not very widespread because like the village level justice committees are considered very legitimate, and they're pretty much considered just. And so their judgments are generally accepted as they are. And so we can see here that there is a commitment to access to justice and inclusion in the justice system. Now, of course, as we said, how fair trial and due process guarantees are interpreted and applied in real life is very different from what we expect in international standards. The reality on the ground is very difficult because of the precarious security situation and resource constraints. And one of the main problems, which I wanted to talk about, is the shortage of professional lawyers. And so there is technically no access to a legal counsel. This can undermine one of the very foundations of fair trial rights, the right to have a counsel during legal proceedings. But we can say that even in those cases, the so-called CBOs, the community-based organizations, often come to the aid of this. They act as justice actors to fill these gaps. We don't have lawyers, but we don't need a lawyer technically according to the fair trial standards. We just need a counsel. And the CBOs often act as counsels. And in particular, I am referring to the role of a very important CBO within the KNU's government structure, the Karen Women's Organization, also known as KWO. The KWO has a very, very important function within the justice system. And so at the village level, where we've said most of the cases are handled, whenever a woman has to appear in court or is involved in any kind of case, she has a right to be accompanied and represented by a member of the KWO who can advocate on their behalf before the justice committees in a way which resembles what a legal counsel would do. And there's also another provision in the KNU law which says that every village should have at least 1 to 2 representatives of the KWO. So the KWO is a very important CBO within the KNU governance structure. They're present in every single village. And whenever a woman is involved in a case or needs to go to the court for any issue, they have access to the KWO in order to get somebody who can go with them and advocate on their behalf before the judicial committee. And the KWO is very proud of this, and in particular, they report that cases of domestic violence and, well, in general, gender-based violence cases have decreased in many villages because, I mean, they report that husbands know that the KWO would assist women, and that women are not scared to report such cases anymore because they know they will get very, very good assistance. And so I have prepared a few burning questions that we can discuss and that basically touch on some of the points that we have already raised. And the first question is, does compliance with international human rights and humanitarian law by rebel justice institutions promote good governance models, which are also applicable by other groups or can be imitated by other groups? So in a few words, they create a virtuous circle of compliance, which can be considered by other rebel groups. And another question that I found myself wondering is, does compliance with such international standards increase rebel groups' legitimacy before the international community? And finally, should the international community recognize and support the efforts of Burmese rebel groups' initiatives aimed at respecting international human rights and humanitarian standards? So those are questions that I was planning to discuss today. And so I would really like to hear your opinions and know what you think.
Thank you very much, Gianluca. I think those questions are excellent for us to consider now. Does anyone? Unfortunately, some people have put in the chat that they had to leave before we got to this discussion point. Does anyone have a specific question? If there's a question through the interpreter, that's fine. I'm going to stop your screen share so I can see people. Thanks.
I think Professor Provost has a question.
Okay.
I mean, if there's somebody else, I've talked already. So, but otherwise, I'm quite curious to hear from Gianluca and Charlie about maybe some of the flashpoints turning, with respect to non-state justice in Burma. sometimes, one of them is gender, and we've heard from both of them that there are some very positive dimensions to gender equality and gender fairness in non-state justice. Another one often is about sanctions used to punish particular crimes. And it's typically related to the fact that non-state groups often don't have prisons to house people for long periods of time, which creates an issue for serious crimes and how such serious crimes are committed. So not really in many places the legal tradition of groups incorporates physical punishment that is, let's say, raises a question with respect to international human rights law. Not really capital punishment is a part of the arsenal of sanctions. And of course, as we heard from Zarli, the state itself makes a fairly liberal use of capital punishment. So there's a question of whether we can blame the rebels for doing the same thing. And if the state does so well, so should non-state armed groups. And finally, and this is related to the last point, often the most difficult aspect of justice by non-state actors turns on the punishment of informants, people who are spies for the government. Typically, this is sort of the acid test of rebel justice, because the tendency is to have very summary justice and extremely harsh punishments for anyone caught spying for the government. So just curious to see whether that rings any bell in the Burmese context for our two speakers, who I should have said that I'm not at all any kind of expert about Burma. I've looked at Burma a little bit, but not in any depth. So I do completely defer to our two speakers on that issue.
Zarli, did you want to respond to those points, or one or more of them?
Okay, so let me go first. So maybe whatever, maybe if there is other, intervention, so I'll also welcome for that. So Professor, thank you so much for your question. So actually that is really difficult and also, a little bit sensitive, but it should not be, but still sensitive in the context of Myanmar. And actually, yes, of course. So Myanmar does not, how can I say, Myanmar didn't apply, even though in Myanmar law, we do have capital punishment, since in, British colonial, let's say. But since in, I think after 1988, maybe one of the student leaders, so that is also in the same group of my ethnic group. So after his, capital punishment, so we never exercise it explicitly, I would say. Like, sometime, that's kind of thing is happened within the inmate or something like that. But officially, we never practiced since in, 1988, because of General Than Shwe. He also signed and released the kind of ordinance or something like that. So, and then in the 2022 July event, four of the political how can I say? I do not want to say prisoner, but I follow the accused person. They were executed in the morning of 4 a.m. That that is what announced by the junta media. So in that four persons, so two were my clients as well. So I didn't had any information, heads of information in regards to this or something like that, because that is not also follow the proper procedure or something like that. So that's why in that area, so when we say it about capital punishment is, it could be justifying the, how could I say, or also it could be, how could I say, kind of, we could say a justice serve or something like that. Because, in let's go back to the 2019 event. Minor age rape case happened. And then a lot of, CSO, women's rights group, or child rights group, they were out to the street and then they protest to give capital punishment. So that's why, and then, in that area, so I'm a little bit shocked because, I'm also, against rape or even minor age rape or something like that. It should not be acceptable. But capital punishment is when we talk about the human's right to life. So that is really against it. So that's why among in the even human rights group, they demand it. But on the other hand, they also criticize it. So that's why that is still, how can I say, still a little bit, how can I say, allowed to discuss about it. And also that is what, I say that is, a little bit, sensitive, but it should not be. And then, as the human rights, lawyers and also who, how can I say, fighting for the criminal justice and also, how can I say, working relentlessly on the judicial reformation. Actually, capital punishment, it should not be, it is not the answer to, how can I say, just adjudicating of the, criminal justice system and also. And then another thing, gender equality things. So the first is, in Myanmar, we are really, how can I say, lack of gender sensitive lens of, how can I say, hearing the cases. You know what I mean? So that is, in the Bangkok rules. So that because, whenever it's come with, sexual and gender-based crime cases happen. So at the time, the very, how can I, tragic story, that is real story in the ground, in the village basis, happen is even the family member or even religious leader force to the victim to marry to the rapist. So they said, this is kind of, the best solution for the coherent or to maintain the women's dignity or something like that. So, and then on the other hand, so for that kind of cases, when the judges is, how can I say, hearing the case, that judges is really do not have gender sensitivity and also a gender perspective of, how can I say, the trial hearing or something like that. And then, the sad thing is the prosecutor side as well. The prosecutor, maybe intentionally or, how can I say, unconsciously, taboo or even, put more traumatized or stigma to the victim in the courthouse. So that's why a lot of women's people, they want women's lawyer or women judges. But sadly, some of the women's, they are, how can I say, they are not really aware of the types of, sensitivity and also vulnerability of the victims been through before coming out, before standing before the court or something like that. So this is also still, gender equality is even, Gianluca is mentioned that, in the KNU, they have a quota system. So even, when there is a quota system, that is, I should be applauded, but actually, women participation should not be, we are still not should be in the quota, right? So because, whenever you go, you will see that a lot of women's educated women and then who is qualified to become for that position, but still there is quota. So which means that, this is like, we feel like, decoration on that, something like that. So that's why that is what I would like to, maybe like, respond to the professor question, and maybe the remaining Gianluca can also add on. Yeah.
Thank you so much, Sia Mazzali. And I actually want to mention, like, you're perfectly right about this, and quotas have some inherent problems, and they're the symptom of a deeper problem. But what I want to mention is that the KWO is also doing a very, very great job in advocating for a greater role for women, regardless of quotas. And I can also mention that the KWO, but also the Karenni Women Organization, are always the most vocal in every meeting that we have. Even with the top leaders, the KWO and the Karenni Women Organization are always the ones speaking up, the most direct. And this is something I really appreciate and I noticed and I deeply admire about them. They're actively advocating for the position of women within their own organization. I think they're doing a very good job, and probably with time they will be able to also change the mindset of others, though it will require time, of course. But hopefully one day we'll not need quotas anymore because women representation will be ensured like by itself without quotas, based on merit alone. And so thank you so much, Siamazali, for pointing this out. And now I want to get back to Professor Provost's points. So we're talking about sanctions for certain crimes, and Professor Provost is asking, this is how we test the justice system. When do we use certain punishments? And in the case of the KNU, as Professor mentioned, the problem of prisons is a common problem among many rebel groups all around the world, and the KNU is no exception. There is no central level prison in the KNU territories. There are some prisons, and there are some detention houses, which are basically kind of like prisons, but not exactly prisons. But when it comes to the capital punishment, we have two things to say. The first one is that capital punishment was used by the KNU in the past 5 to 10 years, maybe. This is what I can recall in terms of time, just 2 times. And it was used not because there were no prisons, but because it was provided by the law. It was said in the law that if you commit rape against a minor, you're punished with that penalty. And this has happened 2 times in the past 5 to 10 years. But it was not because there were no prisons. What happens when there are no detention facilities available is that the person is maybe kept under detention in a normal house. So they get along with that, but they don't have alternative punishments just because there is no prison. When it comes to corporal punishment, to my knowledge, the KNU is not applying that at all. Maybe it is provided in some older laws, but they don't use it anymore. When it comes to informants is again a very tricky and difficult concept. I know only of one case in the KNU where 29 informants were. This was back in 2022. It's a very famous case, so I'm not saying anything really secret. In 2022, 29 informants were extrajudicially executed. And this came from an order of general of the KNLA, and is called Nedamia. Nedamia gave the order to execute 29 informants because he found out they were spies of the Burmese government. The KNU took the matter very seriously, and basically they started a very serious investigation against Nedamia. And of course, it was stripped of his position. It was not a general anymore. But once the investigation started, Nedamia simply refused to, let's say, to participate in this criminal proceeding and simply created a splinter faction. He had guns. It was the head of that specific brigade, and he simply said, "I'm not gonna go to prison. I will simply split from the KNU." And this is how the Kotule army was born. And so the result was a splinter faction, but the KNU was more than ready to take action against him. They were ready to send him to prison. Another difficult thing, and this also justifies why the choice of the KNU to prosecute him was very difficult, is that Nedamia was the son of Pado Bomia, who was a very, very significant leader of the KNU, was the chairman of the KNU from the 70s until the early 2000s. Still, the KNU, even if he was the son of this important leader, the KNU was ready to prosecute him. And he knew that, and that's why he created his own faction, which is a rival now of the KNU and controls a very small territory, but still. And I know about another case of an extrajudicial execution of informants. And basically, it was a case where a monk was executed, but it's not from the KNU, it's from another ERO. So I've heard of this case in a conversation with some of the leaders from this group, but it's not in the KNU. And I'm not sure if I can disclose what group is that, but still, that was also considered very seriously. And the result was that they realized that there was no military law to prosecute soldiers, and there was no law to hear cases of command responsibility. And so they started creating a specific law to address that issue and to prosecute those soldiers or those members of the organization who basically commit extrajudicial executions. And so I hope I answered your points, Professor.
Thank you so much, Gianluca. I wanted to, okay, we have a question, Mitala, and then I'll ask.
Yes, hello everyone. My name is Nitala, and this is not a question, just a very short statement. So I'm a Korean ethnic nationality, and I used to live in Karenni refugee camps for 13 years before coming to Canada almost 2 decades ago. I'm currently based in Toronto. Just want to thank each and every one of you for all the wonderful job that you are doing on the border in regards of this law and legal justice and judiciary, all these kind of things. So on behalf of the Karenni and Karen and everyone, currently based in Canada also, I try to engage to the best as I can with all the other ethnic nationalities across the country. So I'm going to leave my email in the chat box, and then if ever I can be of assistance to your work, please reach out to me, and then I'll do my best to assist you. And then also if I need to do referral, then I'll do.
Thank you, Sayamit.
Thank you. I wanted to ask a couple of things because based on my work and the work of Just Governance Group, I was looking at how can international supporters who want to support pro-democracy movements engage with these rebel justice systems? One, is there an opening not only in Burma but perhaps other countries for the justice operators, so whether they're at the village level or judges at the different levels of courts, open to receiving training on international humanitarian law and international human rights law? That is one. Or would it be like an imposition that is like a cultural, I guess, clash, especially when customary practices are observed? And well, I've seen different reactions in different countries, so I just wanted to put that out on the table. Maybe all three of you have some experience in that. And then the question, and it was one Gianluca asked about legitimacy being, and perhaps recognition, legitimacy of their justice, of a rebel justice system internationally. I've been reading some articles about the Al Hassan case before the International Criminal Court. It was a rebel group in northern Mali, and he was found guilty of crimes against humanity. So, and there's questions around Common Article 3 that Professor Provost mentioned. So I'm trying to think, what is it about that court? Well, that there were arbitrary, that was violent sanctions. One author I read said there was there were victimless crimes, so the prosecutions were often, for alcohol possession or for violations of dress codes, so more strict Islamic codes. So when's that tipping point for a case to end up before the ICC? I find that an interesting sort of dilemma. That may be a dilemma for some of the rebel courts. And so those are my questions. But then there's one in the chat based on, the work in Indonesia or in Aceh. Do you say Aceh, Ibnu?
Yeah, Aceh, yes.
Aceh. Do you want to pose your question?
It's just a comment, yeah,
A
comparing
comment
with
about an
experience in
alternative system
yeah.
of law that
Yeah.
was introduced by the government to degrease the rebellion. Oh, so it has partial Sharia law. Okay. I think that's the challenge where there's different types of laws and customary practice, religious and customary practices being implemented. Does anyone want to respond?
I can respond, if that's okay, to the very first point you raised, because in relation to the second point, in relation to Halasan, I just know that that judgment is very interesting in terms of secrecy patterns and practices, and I've talked about that in my article. But I know that Professor Provost wrote a lot about the ICC and its relationship with rebel, like, courts and decisions on when states are unwilling or unable to prosecute international crimes. So maybe you can talk more in detail about that. I will focus my intervention on the engagement. And that's a very interesting dilemma. Like, how do we engage with non-state actors in a context like Burma, but also elsewhere in the world? I can talk about the case of the KNU, but I think that the Karenni interim government is pretty much very similar. The reality is that the KNU really believes in these values. Like, they don't do that because they think they're going to get a payoff in terms of international recognition. At least this is it's something good, for sure. They're something that they aim for, like to get more international engagement, not recognition, because recognition is nearly impossible, and we have no cases, to my knowledge, in the world where respect for international law by a non-state actor granted that actor international recognition. But still, in terms of engagement, is a very good payoff that can occur. But that's not only the main point. The main point is that the KNU, but also the Karenni interim government, really believe in these values. And they do that because they also believe that this is going to create a good governance system. This is going to make the life of the people better. They're going to be happier with their government. And I can also tell a little bit something about the Karenni interim arrangement, because I heard a few days ago that in the Karenni interim arrangement, there is a clause which says that whenever a law is adopted by the KSIP and it comes from the Myanmar legal system, the judges have to interpret and apply that law coherently also with international human rights law. And so they can disapply parts of that law, they can abrogate parts of that law in its application when they feel that that law is in contrast with international human rights. So this is just a sign that that there's not always a strategic rationale for respecting international standards. Sometimes groups like the Karen and the Karenni simply believe that they are important and that they're gonna make the life of the people better. So, Siam Azagli, do you want to add something to this?
Yes, of course. Thank you. So, thank you, Kim. So, maybe actually, Gianluca is already. Oh, sorry. To cover your number one question. So I would like to just, a little bit to add on, how could, international community can support to the rebel justice or something like that. So currently, so what's my organization and myself, we are working with, judges for the future judges that we mentioned. So, but actually that is also who is, part of the rebel justice, actors. So actually, number of how could I say, judges who appointed each of the, how could I say, rebel or ethnic group or something like that. So actually, they appointed that judges or judicial officer because of maybe at least 1 or 2 years of experiences, or maybe they also educated from the law background, or maybe like they have been work in the court in the courthouse as a clerk or something like that. So that person, those person become a judges right now. So, and then all of the, how could I say, when they hear the cases, or when they, how could I say, ruling, passing the judgment or something like that, it's really, how could I say, intact with the personal bias, I would say, but but I should not be say like that. But that is because of when they written the how could I say, the analysis or court discretionary thought or something like this, really, how could I say, not really interpret the principle of the, how could I say, the code of ethics or something like that. So that is why that is what just after they face a little bit of dilemma, I would say. And then some of the judgment are not really, how could I say, adjudicating because of they don't know how to, how could I say, sentences or something like that. Actually they know that, but I don't know, they don't know how to deliver or interpret justice to be served. So that's why that is what we have been approached by this those ethnic justice areas that to deliver the training, because I have been work in that area more than decades, because the most passion is reformation of judiciary. So that's why I have been work on that. So maybe like as an international community, like Professor Renee, yourself, so maybe like your how can I say, knowledge is really, really vital and also pivotal for the justice actors in Myanmar, because those are emergent, and then they become that how can I say, justice system emerge not because of the state of how can I say, stability, but because of people are, how can I say, cannot people are starving to seek justice or something like that. So that is why maybe that type of, because that's why I also, whenever I deliver the training, not just only put on the principle but also the practical as well. So that's why for me, after now it's been, I think, almost 3 years, I didn't criticize very loudly, because after I understand that their how can I say, shortage and also their sensitivity, their difficulty. So that's why I understand it. So that's why when Professor Renee is asking the how can I say, the informant, that types of thing is actually, I even become biased right now. So I should not be, but because of I really close with them, and then I really close, how can I say, knowing all of the detail of the cases or something, like I become even this is really, how can I say, things that could be happen. So that's why maybe like the international community can support technically, and also, but that technically it not should by driven from the international perspective, but from the, how can I say, bottom up, so that they will feel that this is not just we are, how can I say, this ideology is not from the Western idea, and this is from the bottom up. That is what I also work since in 2014, my Chin community, that women's right perspective or something. And then they said, this is because you travel a lot, so that's why you are also learning, and then you are influenced by Western or something. And then no, I just only travel there for a couple months, so it could not be how can I say, influenced by that. So, and then after that I study about my own how can I say, customary practice, because, Chin is, we do have a more than 50, customary differences, differentiated or something like that. So I learned that, and then I studied that, and then I use their understanding of that language, and then I interpret it based on the ethnicity and religious and also customary practice. They understand it. So that's why, whenever we work with that, so it should really, how could I digest the local understand language is also really important. Sometimes, some people, if they use very heavy word and the technical term, it's make people, how could I say, reluctant to apply those types of, understanding. So that's also really important, means, learning thing. And also the legitimacy. So actually the legitimacy for me is that, a lot of people is mentioned, this is political will or something like that, but, legitimacy is only in the people hands, the people who are living in that areas, if they legitimize it, if they recognize it, that justice system will be prevail. So that is what I normally say. So thank you.
Thank you. Yes, Renee, I wanted to call on you, and I think then we'll sort of your last comments, and then we'll wrap up the roundtable. Thank you.
Yeah, thank you. It's I think, really interesting, important conversation. Many very good points, also very complicated points, including about, the impact of cultural difference. But maybe I'll just come back on one aspect, which is what can anyone do to help, and what can outside actors do? My sense is that as far as governments are concerned, governments are on the whole extremely reluctant to become involved in any way, regardless of the unjust nature of the regime and the, democratic, egalitarian, legitimate aspect of the non-state group. And we've seen that in a number of places. I have tried in the past to, get the government of Canada to move to support people that they otherwise were supporting militarily. But sending special forces is okay. Sending people to support non-state justice institutions seems to actually be a bigger problem for government. I think that there's one organization that I want to mention, and that is Geneva Call, an NGO based in Geneva. That works with non-state armed groups, including in Burma, and they get groups to sign deeds of commitment, including the Chin National Front, for example, has signed deeds of commitment. I've worked with Geneva Call since, relatively early in my book project on rebel courts. And they, grew out of a movement to ban personal landmines, and then went on to cover child soldiers, the protection of women, healthcare. They're very reluctant to get involved with non-state justice because I think they feel that this is such a explosive or toxic issue for the government that the local government, whatever it is, will react badly if they are seen to play a role in helping to build up local non-state justice institutions. I think that the only way that I see they might get involved is if groups themselves ask Geneva Call to provide assistance. And I think that they do have an expertise that is unique in trying to figure out, what's realistic for a non-state armed group operating in a conflict zone, confronted with extremely difficult circumstances, choices. As Ali was saying, we're lawyers, so we tend to find the flaws, but it's important to realize, to underscore how important it is, how much often this is a demand from the people that the group do something about justice in the areas under their control. And if the groups fail to do so, it does sometimes lead to vigilante actions. Gianluca mentioned a case about sexual assault against a child, and this is the kind of example one hears often, where the group reacts because otherwise they're going to just kill the guy, and so they create a process, and so it's not always strategic, but it is part of sort of the raison d'être of the group. Why we fight? Well, we fight for justice and emancipation, and bringing justice to the people is a natural part of that. So I think that a realistic international avenue to provide support for non-state armed groups in conflict zone, I think, is an organization like Geneva Call to expand on its mission much more than counting on intervention by states or by international organizations or by institutions like the International Criminal Court, which there's just it's very unlikely that there are any helpful answers that come from that respect. But I really a great conversation, I thought, today.
Thank you so much, Renee, Gianluca, Zarli, and all the participants, Tin, for interpreting. Thank you. I've had a number of people write me who'd registered and then said that they hope that this would be recorded. So we will be uploading this, and I'll share the links with you, and you're welcome to share the link to the video recording. And I wish you all the best of luck in your work, and thank you again for your insightful comments. It's been very, very special for me, and I think Tin and I are wrapping up relevant work, and I think this will be very useful. Thank you. And thank you to the participants from different parts of the world for joining us today. Thank you.